All right, let's get some analysis on this particular story, and we are joined by legal expert Ajay Chagan, who talks to us now. Mr. Chagan, thank you very much for your time. Your assessment on how proceedings are going here. There is a very clear frustration from the judge, Chifiwa Maumela, that this is the first and last postponement that this case will see. Beyond the 22nd of April, there will be no further postponement.
Good morning. Thank you for having me. Yes, the issue of postponements is always a vexed one. I can understand why the judge is frustrated at the fact that the defense counsel is now seeking a further postponement, as this matter, as we all know, has been dragging on for a number of years. However, we must always remember that it is a tricky task for the court to balance the rights of the accused vis-a-vis the rights of the victim or the victim's family or society, as it were. The fundamental complaint of the defense is that the accused has not had sufficient time to prepare his defense. And we all know that in a constitutional democracy such as ours, everyone is entitled to a fair trial. And that justice must, as the adage goes, must not only be done, but must be seen to be done. And that means it must be seen to be done by both the accused and by society.
All right, let's go back to some legal analysis now. And with us is Ajay Chagan, who we rudely interrupted. I apologize to you, sir. Let's pick up on what you were explaining about the further postponements. And you and I were discussing that the judge clearly hard-pressed to give this latest postponement, but he's very clear that beyond the 22nd of April, there should be no further postponements.
Yes, yes. As we were saying, it is a balancing act that the judge is confronted with in order to balance the rights of the accused and the rights of the state. As we all know, the accused is entitled to have all the information presented to him in a timeous fashion in order to adequately prepare his or her defense. And the fundamental complaint of the defense was that this was not the case in this matter. Documents were given at a belated stage, and that it would be prejudicial for the accused to continue to be put on his defense without actually having had an opportunity to canvass all the allegations against him.
Yeah.
Now, having heard that, the judge was then obviously in the position where to weigh up the interests of the parties, and it was under those circumstances that he agreed to the postponement. But we've also heard that he said it's a final postponement. In other words, he's cognizant of the fact that there are other parties whose rights are being now negatively affected. And it is in the interest of society and the interest indeed of the accused for the matter to now proceed. So he set a date, he's given an ultimatum, it will proceed on the 22nd of April, and let's hope that that is the case on the 22nd of April. Can I just quickly add that, it's funny that while the judge could have said it's a final postponement, there actually is no such thing as a final postponement, because trials are dynamic things by nature, and various things can happen between now and then which might result in a further postponement. A witness could fall ill, one of the accused could fall ill, some information could go missing, the prosecutor for whatever reason might not be available, the judge might not be available on that day. So while we understand that it is a final postponement, we must also just be alive to the fact that, in the fluidity of these type of natures, anything can happen between now and the 22nd.
That's a very interesting point you raised there, because that talks directly to, for example, you would have heard in court that the accused are being kept in separate prisons, and this is in part for safety issues or safety reasons. Let's deal with those first before we get to the protection of witnesses, which is another matter that the judge came out strongly on. Why is it important that they kept at different prisons?
Well, there's no prerogative in terms of our legislation that they be kept in one prison or they be kept in separate prisons. That's a logistical decision that the Department of Correctional Services has taken for various reasons known to them. One of them might be the safety of each of these prisoners. We must understand that Senzo was an icon in the eyes of the South African public. We're not just talking about a matter here which does not have significance. Senzo's murder resonated with our society to a large large extent. And the prison authorities obviously considered that when making the decision to keep them in separate prisons in order to keep them isolated from other prisoners who may or may not pose a threat to them. I'm not privy to the facts or the considerations that the prison authorities considered when making these decisions, but that would certainly have been an element that would have come into their thinking.
Yeah.
Insofar as the safety of witnesses is concerned, the second part of your question, that's also critical. I mean, it's not unknown in our law that witnesses are put into witness protection programs until they've completed their testimony and even for a period thereafter, because the lives of witnesses who testify might be at stake. And we come across that in high-profile matters of cash in transit and, other such type matters where witnesses are indeed fearful to come to court to testify. So measures have to be put in place to protect them and to ensure their safety if they do cooperate with the state.
Yeah, and that's a critical matter because in recent days, it is not unheard of in South Africa that witnesses are allegedly eliminated at the hands of the very awaiting trial prisoners. All right, let's deal with the final matter, and that has to do with what clearly is the difference between accused number 5, who is the reason why we're seeing a postponement, and the rest of the accused number 1 up until 4. They are saying that they want to be preferred with the charges because they have no clue as to why they're being accused of this particular case. And accused number 5, on the other hand, wants to consult defense witnesses in the 2 provinces, KZN and Gauteng. What do you make of these differences? Might we learn something here? There's also talk about a plea agreement or some sort of plea deal. What could that talk to?
All right, let me answer the last question first. A plea agreement is governed in terms of Section 105A of the Criminal Procedure Act. And that simply means that a witness comes forth and his team, the defense team and the state will come to an agreement where if he pleads guilty, they will agree on a possible sentence and how he should be sanctioned. So it is what we call a plea bargain. Now, if that is a possibility here, I would have imagined that that would have been considered before today because the trial was due to start today. So issues of a plea bargain would have been considered today, and I would suspect that those negotiations were not successful because they had not yet come to fruition. It appears as though today all the accused were being placed on their defense. Now, insofar as the difference between the first 4 accused and accused number 5 goes, I must state at the outset, I'm not privy to any of the evidence that might be laid here, so I cannot speak with specific authority. But just in general terms, it would appear that the evidence linking accused number 5 would be stronger than those linking accused 1 to 4 in this matter. Accused 1 to 4, it would appear, are denying their involvement in all of this matter, and it is up to the state to then prove their involvement insofar as the state alleges that they were involved. However, accused number 5 seems to be directly implicated. There is evidence implicating accused number 5 that does not appear to be incriminated in accused 1 to 4, which is what puts accused 5 in a separate boat, and which is why he needs to consult with other special witnesses who may corroborate his defense, and those witnesses may not be required against the first 4 witnesses. So that would appear to be the distinction in this matter.
A very, very clear and detailed explanation there. Thank you very much for that legal analysis, Ajay Chagan, explaining to us just some of the legalese surrounding this particular case.